So I think that what we've got through this morning is a series of presentations that show that there is not one land question. There are many land questions. Urban and rural, the questions of redistribution, restitution, tenure reform, upgrades, who expropriates, who benefits, etc. And of course the question about land has been thrown into the spotlight, as Ben said earlier, by the resolution that was adopted on Tuesday the 27th of February in Parliament to appoint a constitutional review committee that will have between now and the end of August to look into whether or not it is necessary to amend or review or amend the Constitution to make possible expropriation without compensation. So that is merely one among many land questions. In your packs, and I think it's really worth having a little bit of a focus on the letter of the law when we talk about this issue, I want to just reflect on the story of the creation of Section 25, the property clause in the Constitution. Of course, there's nothing quite as polarizing for South Africans as debating the property clause in the Constitution. Many years ago, in 1995 actually, I was doing my first honours thesis on land reform during the negotiation of this. And what I found very striking, going to the Constitutional Assembly at the time, was to realize that it wasn't just commercial farmers who were arguing that their property rights should be insulated and protected in a property clause. It was mining companies, it was financial institutions, and of course the property clause refers to property in general, not just land. So let's keep that in mind. Secondly, I think that there are many ways to look at at Section 25 on property. My argument, and you can go through it and we can debate this, but my view is that the negotiations at that time went along these lines. The National Party, the Democratic Party, a whole lot of groups within South African capital and society were arguing that there should be a property clause that would insulate and protect private property interests. And at the time, the ANC and several other parties opposed the idea of having any constitutional provision around property. And what was agreed ultimately is that there would be a constitutional section dealing with property, but that it would not insulate existing property rights and rather provide a mandate for transformation. My view of it, if we read from section subclauses 1 to 9, subclause 1 prevents any form of discriminatory form of deprivation of property, but it doesn't say that there cannot be deprivation of property. And that the other 8 subclauses are in many respects the mandate for transformation. So there can be expropriation not only for public purposes but also in the public interest, which means land reform. And of course, the state expropriates on a regular basis, but it has never expropriated for land reform purposes, despite the provisions of Section 25(2). And I'm quite struck, last year, I think it was last year, former Deputy Judge President Dikram Moseneke was complaining and saying, we sit within the Constitutional Court waiting for a case to come before us so that we can rule on what is just and equitable compensation. And we've never had a case. We can't make jurisprudence if we don't bring us cases. Tembeka Ngqukatobi, as I mentioned, has made the first attempt to interpret Section 25(3 and to say, okay, let's look at the history of how our property was acquired. Let's look at how it's being used now. Let's look at the purpose of the expropriation, and we are not going to offer market price. But the truth is that we simply don't have a record of trying to use these processes. Since 2008, there has been an expropriation bill moving very, very slowly through Parliament. In 2016, it was passed, and the President has sent it back, arguing that there was insufficient consultation in the NCOP. So I think that we're going to be in a situation within the coming year or two where we're going to need to look at both the Constitution but also the expropriation legislation. Our current Expropriation Act is an act of 1975, which says that there can only be expropriation for public purposes, not for land reform or private in the public interest. It also requires market level compensation. So we have a disjuncture between what the Constitution, what the property clause mandates in terms of expropriation and what our guiding legislation says. So I think that one place to look is what happens with the Expropriation Bill that's now back in Parliament. It's quite possible, in fact, that there might be an amendment to the Expropriation Bill that would clarify the kinds of circumstances under which there could be expropriation of property without compensation. In which case, we might be able to clarify a policy position and embed it within the Expropriation Bill. There are various different possible scenarios for the future. As I think it's already been said, the DA is trying to position itself like we are going to do expropriation without compensation in inner city Joburg, but fundamentally the DA is opposed to expropriation without compensation. My view is that one of the big untold stories is the difference between the thinking within the ANC and the EFF. So they seemed to agree in February. They voted together. But they actually mean different things by expropriation without compensation. There's a big difference between nationalization of land, state custodianship of land, or the ANC predominant view in my understanding, which is that the ANC wants to be able to expropriate with or without compensation or buy on the open market. It wants expropriation without compensation as one tool within a toolbox, entirely different from the EFF's view. So I think that a big story to be told between now and August is what happens within this Constitutional Review Committee. What are people saying in the public hearings that are going to be happening across all the provinces? And let's distinguish also conceptually between expropriation and compensation. We haven't expropriated, even though we could have. The requirement is just and equitable, that the amount of compensation and the time and manner of payment must be just and equitable. Of course, an amount could be zero if it is just and equitable to do so. So, there's an open argument. I think that there's been a lot of hype and hot air around the Constitution. The Constitution's requirement is not that you must pay money or that you must pay market price, but that any compensation must be just and equitable. So it's an open question of how would a rephrasing of this section of the Constitution happen. So expropriation is a process through which the state can break a deadlock. And so my view, my understanding of the Constitution is that it says that there are property rights for those who hold property, but those are not absolute property rights. But there are also property rights for the dispossessed, for people who lost land in the past, for people who don't have access to equitable access to land, or who don't have legally secure tenure. So we have sets of property interests that can, in practice, run up against one another. My view is that one of the key areas in which we need to be expropriating is where there are restitution claims on land, where people are occupying land and don't have secure rights to that land, etc. So expropriation is one question. The question of whether or not to pay compensation and how that level of compensation is to be determined is a separate matter. After August this year, if all goes according to the timeframes, Parliament will need to hear the outcomes of the Constitutional Review Committee, and any proposal to change the Constitution will need to be passed by a 2/3 majority. I think there's an open question about whether or not politically the ANC, together with the EFF or other parties, can come together to agree on any potential rewording. Of course, all of this is subject to the limitations clause. So section 25(8) is very important because it says that any limitations of rights to property must be done in line with the limitations clause, which says that it must be reasonable or justifiable. Any limitation of a right must be legal and justifiable. And that would require a 3/4 majority. So I think that there's an open question. My view is we're probably going to be looking at, even before passing a change in the Constitution or the Expropriation Bill, we're probably going to start to see some test cases being prepared. And we probably should be thinking of several kinds of examples. Lauren has already referred to certain situations where there might be a very strong argument for expropriation with no compensation, including inner city buildings where we have absentee landowners who have failed to manage and maintain properties, and who are not paying rates to the city. Also, informal settlements. A third example, I think, is going to be labour tenants, and we may be seeing this Msiza case coming back. And, you know, the reason being for expropriating without compensation is that labour tenants already occupy and use portions of land. The private title holders don't have effective occupation and use of the land. And I know that within the ANC they've been saying a lot about the fact that underutilised land, or land held by absentee owners, or land that is being seen as being held purely for speculative purposes and not being used, should be targeted. So we're probably going to be looking at a situation where the big question is one of policy, actually. Under what circumstances should there be zero compensation? Should there be partial compensation in some cases? Should there be market-related compensation in certain situations? And one point that I would want to emphasize is that given that a lot of people who are deprived of property rights in South Africa, even though we don't have an expropriation process under land reform, are poor and black. And we're seeing expropriations and dispossession, for instance, in communal areas to make way for mining deals. Should we have an approach that actually has an affirmative action rationale, which is that people should be left better off after expropriation of property? So I think there's a broader set of questions, and we probably should be discussing what's the real politics around the land question and the ways in which this expropriation without compensation has been framed as if it was going to resolve all these many complex land issues that we've discussed this morning.
Thanks, Ruth. So just to clarify, so there are questions of how we interpret the Constitution, the wording of the Constitution, very important. There's also the policy questions, which Ruth has raised here. And that leads, part of that is whether or not expropriation, at whatever level of compensation, can ever be the major mechanism through which land is acquired for land reform purposes. There's not a straightforward answer to that. And thirdly, there's the question of how all this relates to the current politics of land. And I just want to say, yesterday, in the same venue, a group of about 50 civil society activists, various kinds of organization, including village-based activists, gathered together to discuss how they were going to take advantage of the Constitutional Review Committee hearings to make their views known, not only on the expropriation question, but on issues of Sections 25(5), 6, and 7, redistribution, restitution, and tenure reform. And we can provide contact details for you for those activists. There will be a press release next week, and I think that's another space to watch. So there are three sets of questions. What does the Constitution say? What are the policy implications? And what are the current politics of land?
You asked a great question about Mala Mala. I think that you actually answered your own question, which is that the Mala Mala case, Mhlangesweni, would have been the first time that we had a judicial interpretation of Section 25(3), which is to say, what is just and equitable when we weigh up very valuable piece of land, enormous this isn't about agricultural enterprise, but huge market value. There aren't actually very similar kinds of properties, so it's quite hard to estimate what the value of that property was. And the variation in valuation was so wide. It was between around 400 million and just under $1 billion. And so, yes, this would have been the prime opportunity if the state wanted to drive expropriation and wanted to get a judicial interpretation of just and equitable compensation, then it would have carried through with the Mala Mala case. Ben has mentioned, the view of historians who are saying one of the reasons why the state decided to settle and to pay out cash instead of going through with the court case is that they weren't actually sure that there was a valid claim. They weren't convinced of their own archival and historical research. But I do think, it was withdrawn. I think it was 2 days before, or it was the Friday, and it was set down to be heard on the Tuesday. And the state paid out 1/3 of the national budget to one family instead of having this court case being heard in the court. So yes, they're huge, and doesn't that also just summarize the debates between what is a private interest and versus what is the public interest? So the public's interest was not well served in the Mala Mala case, but it served the private interests of one family very well. And of course, I think that it would be great if the media were to follow up on what's been happening with Mala Mala, because they entered into a lease-back agreement, which is at far below market rate. So the same family that's been paid out R1 billion of our money retains ownership and control over that enterprise. Question about, of the claimants, what benefits are they getting? We don't know. In terms of John's question about what happened in the Zuma years, so I think that there's an inverse proportion between rhetoric of radical economic transformation and actual land reform. In fact, in the high-level panel report, there is a graph that we developed based on official data that shows the demise of land reform. So the high point of delivery was in 2007-2008 financial year, and since then it's been plummeting to the point that basically a lot of land redistribution has stalled. So yes, the land reform program has been dismantled under the Zuma administration.
And sorry, just legislatively, did the Zuma administration push for anything that approximates expropriation without compensation? Did they ever put that on the table?
No, but of course they did. What has been happening under the decade or so of the Zuma administration is the creation of the Expropriation Bill. But the Expropriation Bill is not about without compensation, although, as I mentioned, it now might be amended in order to make provision for expropriation without compensation. What it says is the state may expropriate, including for land reform purposes, and it is in line with the existing wording of Section 25. So, my view is that irony, perhaps, is that the Mandela years started really slowly with land reform. The Mbeki years, although there was a lot of elite capture and a lot of a shift away from the pro-poor focus, actually saw greater delivery. And the Zuma years have seen the dismantling of the land reform process.
PLAAS and policy?
Oh, sorry? Oh, I don't know what to say. As SERI and PLAAS, we are talking quite a lot about expropriation without compensation. And that's why, we've been we suggested this event was to broaden out the debate. So we're saying the same things to everyone.
Just to say that in the early years, 95 to 99, people at PLAAS and many others were very involved in the policy-making process. After Mr. Mbeki came to power, we were basically shown the exit door. And since then, we've had a very adversarial relationship with the department, although despite our efforts to enter into productive dialogue. And it remains very adversarial. However, under the new leadership of the ANC, there are the beginnings of a thaw, so we'll see what happens out of that. I don't know if Siri would like to comment at all.
Thanks. I wanted to comment very briefly on the question of politics. I think that it is undoubtedly a political and a politicized question. And for organizations like SERI and many others that I know of, one of the biggest challenges has been how to respond. It seems like an enormous opportunity, but there's a healthy dose of skepticism. And I think it is both. It is an enormous opportunity, and we're right to be skeptical. So I think, and I speak in my personal capacity here, that one of the things we have to work to ensure is that there's a programmatic approach to expropriation in place before elections in 2019. If we're able to achieve that, then we have something with which to hold government to account post-elections. And by the way, the skepticism is obviously not just shared by sort of intellectuals and policy advisors. The other day when I was at an Afro meeting with farm dwellers themselves were saying, we don't believe this. We don't believe it will change our lives. We need to represent ourselves more strongly. And yet, most of them are ANC supporters. It's a complicated politics, I think, but it is undoubtedly political.
If I can just add to that, I think that in the same way in which we've been talking about the fact that there's already enormous scope within the Constitution to expropriate with or without compensation, I think that what this has opened up is the range of other land questions. So in that sense, it's an enormous opportunity. And coming quickly on the back of the high-level panel report, Kgalema Motlante's report, and by the way, can I just emphasize, even though it's enormous, if you just read pages 200 to 233, you'll have the gist of the whole land story. And so I think that we have a very compelling argument about what are the issues, what have been the legal and constitutional frameworks, what have been the implementation modalities, what have been the outcomes, and what needs to be done. We have it all there. So I think that this opening up of the land debate, while technically the Constitution may not be the stumbling block, it's opening up these broader debates, which is very functional for our society.
Thanks. We have to move to closure. Just let me make 3 quick points. Firstly, many of the problems of land reform emerged under Mandela and Mbeki. But what we saw after 2009, when Mr. Zuma came to power, was large-scale processes of elite capture and associated and institutional dysfunction. We talked about the commission earlier, but also of corruption, and it's happened in the land reform sector. For example, one case that you might like to follow up, and it's reasonably well documented: South African fruit exporters, SAFE, together with their BEE partner, pro bono, one man, Evans Mavondo, having acquired about 20 farms or so, 20 operations in the citrus industry. Often they've done this by acquiring a farm at market value, selling it back to government at a vastly inflated price, and then becoming the strategic partners of the new owners, who often put on one side, SAFE run the operation and process and package the product, and are scoring massively. No action has been taken against them. A special assignment investigation, Hazel Friedman, is focused on one such case, in the Rwanda case in the Western Cape. There's several episodes of special assignment. The fingers point to this advisor, to the minister, and possibly to the minister himself. No one has ever written about this. It's only been covered by special assignment. But secondly, I think what we've seen in the urban sector is a reproduction of spatial inequality in the cities. Poor people are located on the periphery or in abandoned buildings. Basically, the cities operate as the apartheid city used to operate. In agriculture, we've seen the reproduction of the divide between large-scale commercial agriculture, increasingly large and international, and a mass of smallholder farmers. The same applies to our country's transport systems. Basically, structurally, very little has altered since the end of apartheid. The key beneficiaries of democracy have been a small number of black middle-class people who mostly work for the state. We haven't addressed the fundamentals at all. That's what's at stake here. Land and rural areas are relatively marginal in the wider economy. The larger problems are 37% unemployment, over 50% of people live below the poverty datum line. How are we going to address these issues? So we have a politics of the moment. We have a new president. Just let me just say that I've been informed by an insider that the new minister appointed by Mr. Ramaphosa, Maita Ngwane Mashabane, does not want the job. So the question is, who in the ANC is going to lead on this issue? The EFF has seized the space. The ANC has granted them that space. They're scrambling to catch up. But what's happening? There's no clarity. So I think yesterday's meeting of civil society was very interesting because a discussion took place about policy making from below, as happened in the early 90s. Perhaps civil society has to provide leadership on these issues. Is it strong enough? Is it capable of doing that? Another idea which was discussed was, Lauren talked about occupations as a legitimate way of gaining access to land. Perhaps this is the moment in which land occupations in general are going to become a way of driving a community-based program of land reform in which the state is asked to facilitate, but we don't rely on an incompetent, if not corrupt state to drive the land reform process. These are the key political questions which I'm sure as journalists you're very interested in. Any final comments from the floor before we close?
Thank you.
Okay, that's it. Okay. In that case, thank you so much. I think that we'd like to, as PLAAS, We initiated this idea, but very quickly the Nelson Mandela Foundation jumped in and said, how can we help? Can we support this? So we'd really like to thank the Nelson Mandela Foundation for making today possible. Thank you. To Khalil and Sumit.